let's now come to user rights, which you think are sufficient in the current bill. There are one or two which existed in the earlier versions, like the right to data portability, which has been deleted. There is, I think, in the earlier versions, we also had the provision of compensation if there has been a data breach. That has been deleted. But rights like right to get your data corrected or deleted, or the right to be forgotten, they continue to exist. In practical terms, do we have, in terms of rights, sufficient in this bill?
Yeah, so this is the one thing that I'm a little disappointed about. I think the right to data portability is extremely important. It is the direction in which data protection laws around the world are going. We've had the right to data portability for a while, since 2016, actually in the law in GDPR, but from even before that, this concept has existed. And the European digital strategy is doubling down on the right to data portability with these data spaces and things that they're creating. California has got a strong data portability provision. The OECD has got working groups on data portability. So to find that missing in this law, it was a bit of a disappointment. I think, particularly since India has got powerful digital data transfer infrastructure, like DEPA and ONDC that we've spoken about on this program, we really need to have a right to data portability in the law. If you look through the provisions, it's there. It's hidden. It's hidden under a carpet somewhere, and you can string it together with a lot of provisions. I don't think it's completely missing, but I would have liked to see it front and center as a right to data portability. I think compensation, not just for data breach, but compensation also for any harm that's caused. We've got I think a good definition of harm now. In the law, the previous definition was just too large, too sweeping. This one seems to be a lot more measured, and I think when we have a definition of harm, it would be nice to see some consequences for harm. The consequences for harm right now are just penalties, but the people who are harmed don't really get anything out of it. So to have some sort of a provision of compensation, even if it's just a thin line which says that you're entitled to compensation for the harm suffered, I think would be a good thing. I don't know if you're going to come to this, but I heard your Twitter Spaces yesterday, and there was a discussion around data breach. And I think people are happy that the data breach notification now extends to all the affected data principals. I think this would be extremely dangerous. I don't think ordinary users are aware of the volume of data breaches that happen, particularly since the definition of data breach is so broad that
you're just referring to the fact that data fiduciary will need to inform the data principal of that breach. That's the point you're referring to.
Right now, the obligation is, the obligation was that the data regulator, the Data Protection Authority, now the Data Protection Board, needs to be notified. In this draft, there's also an obligation to notify all the affected individuals. And the reason I have a problem with that is that the standard around the world, Europe, for example, uses the standard of you inform the data principal or the data subject in Europe when there is a high risk that their rights and freedoms will be affected. Now, the nature of data breach, given the definition of data breach, is that even if I leave my laptop in a taxi, I have lost access to the data in that laptop. And even if the taxi driver has no way to open it and see the information in it, it constitutes a data breach. Now, at this point in time, when no harm has been caused to the individuals in that whose data I have in that laptop, do we call them and tell them, look, I think your data is stolen? Do you want to create this sort of a panic? There are hundreds of incidents like this that happen in companies around the world. And please understand that data exists everywhere. So to actually create a regime where every time there is a data breach, as defined in the law, everyone gets notified. One, you're going to cause panic. Two, after the initial panic, people are not going to pay attention. And so when there is a real data breach, they're going to say, oh, okay, this is just another one of those laptops left in a car. This is not the regime that we want. We've got to have a more nuanced regime around data breach notification, because it's these small, innocuous provisions of the law that are murder to implement when you are a company trying to do the right thing by your customers.